Maria was sitting on the side of the road in Houston when the other driver walked over and asked if she was okay. "I'm fine," she said. She just wanted it to be over. Knowing what not to say to an insurance adjuster after a Texas car accident is something most people never think about until it's too late. Maria didn't think about it either. And that one answer she gave on the side of the road ended up costing her more than the accident itself. The other driver's insurance company had a claims adjuster assigned to her case within hours. That adjuster's job is not to help her. Their job is to build a file that limits what they pay out. The moment Maria opened her mouth, she started building that file for them. There are 7 specific things I see people say after a crash that quietly undermine their own claim. One of them you'll actually hear from your own doctor. Another, the adjuster will ask for it and make it sound completely routine. Both are traps. Number 1, "I'm okay." This is the most common mistake I see, and it makes sense in the moment. You're standing on the side of the road. Adrenaline is still running through your system. Someone asks if you're hurt, and you say, "I'm okay," or "I'm not injured." Because in that moment, you genuinely might not feel anything. The problem is, soft tissue injuries, herniated discs, even concussions often don't show up for 24 to 48 hours. The pain arrives the next morning or the next day. The stiffness and swelling sets in later. By then, the adjuster already has a statement on record from you saying you weren't hurt. And they will use that statement to argue that your injuries didn't come from this crash at all. That one sentence can harm your claim substantially. What to say instead? Tell them you're not sure yet. "I don't know if I'm injured," is a completely honest answer. Get checked out by a doctor first. Then you'll know what you're actually dealing with. Number 2, giving a recorded statement. The adjuster will call you often within 24 hours of the accident. They'll introduce themselves, they'll sound helpful, and ask if they can ask you a few questions. They may say it's just to get the facts straight, and then they'll ask if they can record the call. Do not agree to that. A recorded statement is not a neutral document. Every word you choose, every pause, every hesitation goes in their file. Adjusters are trained to ask the questions that seem factual, but are actually designed to get you to minimize the crash or your injuries. How fast were you going? How fast away was the other car when you first noticed them? These sound like routine questions, but they're not. They're building blocks for a defense. In Texas, you are not legally required to give a recorded statement to the other driver's insurance company. Before you ever speak on the record, talk to an attorney. That one step protects you from a document that can follow your case all the way to trial. Number 3, admitting any partial fault. Even if you think you were partly responsible for the crash, don't say that to an adjuster. Texas follows a comparative fault rule. Under that rule, if you were partially at fault, your recovery can be reduced by the percentage of fault. But if you're found to be more than 50% responsible, you're not able to recover anything. That's called the 51% bar. Fault determination is a legal process. It's based on evidence, witness statements, and accident reconstruction, not on your gut feeling in hours after a crash. Saying, "I should have seen them coming," or "maybe I was going a little fast," locks in an admission before the process even starts. Let the evidence determine fault, not your guilt. An adjuster is not equipped to make that legal call, and you shouldn't make it for them before the facts are even gathered. Number 4, accepting the first settlement offer. I've had clients come to me after they've already signed. I've had clients come to me after they've already verbally accepted a settlement. They may have taken a check or just verbally agreed, thought the matter was resolved, and then a week later, they found out that they needed surgery or some deeper medical care on their back or neck. That settlement include the release of all future claims against the driver and their insurance company. The insurance company knows exactly what it's doing. When they get you to agree to a settlement, you're bound. First offers are almost never close to what a claim's really worth. They come in before the full extent of your injuries are even known to you, before lost wages may have added up, before surgery or long-term rehab costs are even documented. The insurance company is hoping you'll accept while you're still rattled and before you understand the full picture. Once you agree to a settlement, there's no going back. If you receive a settlement offer, talk to an attorney before you even respond. This is not a step that you can undo. Number 5, posting on social media. After a crash, it's natural to want to let people know what happened. You want to tell our story. Don't. Defense attorneys and insurance companies have investigators who monitor social media. A photo of you at a family event looking fine 2 weeks later after you claim a serious back injury is evidence they'll use against you. A comment saying, "finally starting to feel better," can be used to contradict your own treatment claims. Even a photo that someone else tags of you in it, one you didn't post yourself, that can end up in their file. And it's not just what you post. It's what you like, it's what you comment on, it's who you check in with and where. Any signs of normal activity become potential evidence or argument that you weren't hurt as badly as you said you were. The rule is simple. Say nothing about the accident, your injuries, or physical condition on any platform until your case is fully resolved, and be careful what you post. Number 6, downplaying prior injuries. The adjuster will ask you about your medical history. You had a back issue 2 years ago. You mentioned it because you wanted to be honest, and the adjuster takes that and uses it to argue your current pain is pre-existing. This accident didn't cause it. I've seen adjusters pull up medical records from 3, 4, 5 years back looking for any prior mention in back or neck pain. If they find it, their argument writes itself. That is their standard playbook with prior injuries. Here's what matters. In Texas, if a crash aggravated a condition that you already had, the at-fault driver is still responsible for the degree to which they aggravated that condition. That's a valid claim. They take you as they find you in Texas. But if you've already told the adjuster your back was basically the same before the accident, you've handed them an argument they need to deny your claim. Do not discuss your medical history with an adjuster before speaking to an attorney. Number 7, waiting to see a doctor. If there's a gap between the accident and when you first go seek medical care, the insurance company will use that against you. Their argument is straightforward. If you were really hurt, you'd have gone to the doctor right away. It doesn't matter that you were hoping you would get better on its own. It doesn't matter that you thought you could walk it off. That gap in care becomes a red flag that they will point to at every stage of your claim. And it's a hard one to overcome. They'll get checked out even if you feel okay. Get the evaluation on the record right away. The sooner you are documented in the medical system after a crash, the harder it is for them to argue you weren't seriously hurt. Simmons and Fletcher has been helping accident victims in the Houston area since 1979. We're proud to say that this is all we do. If you've been through this before, tell me in the comments below. Did an adjuster ever ask you for a recorded statement? How did you respond to that?